Kia ora and welcome to the HRPI. I'm Marie Tovio, Registered Private Investigator, Employment Relations Expert, and your go-to advisor for navigating the trickiest workplace matters. Today's case is one I see often, and it involves workplace investigations. Maybe someone's been accused of bullying, harassment, discrimination, or serious misconduct. Maybe there's a clash between colleagues that's escalated. The question is, when should you investigate, and how do you do it properly? Let's start with this. An investigation isn't about proving someone guilty. It's about gathering facts in a fair and impartial way so the employer can make an informed decision. That's why the process, not just the outcome, matters so much. So when do you need to carry out a workplace investigation? Generally, you should consider a formal investigation when allegations are serious, especially if they involve harassment, bullying, discrimination, or potential breaches of policy or the law. Even if it feels uncomfortable, failing to investigate could put your organisation at risk of failing its obligations under the Employment Relations Act, the Health and Safety at Work Act, or both. Other legislation, such as the Privacy Act, must be complied with as well. However, before you initiate a formal investigation, you should check whether informal options might resolve the concerns, and in the case of a complaint having been raised, whether or not the complainant or complainants have given permission to share the information that they have provided with other relevant parties. Now, what does a fair investigation process look like? Today I'm going to focus on investigations relating to a complaint. Another time I'll discuss disciplinary investigations. So send me any questions you have about those. So with a formal investigation into a complaint, first you might need to undertake some preliminary inquiry with the complainant if the information they have provided is unclear, or if you need to check things such as whether they give consent for the information they have raised to be shared with other relevant parties. Next, you must notify the person or people accused, also known as the respondent, and give them a copy of the allegations. They need to be specific and clear. Inappropriate behaviour is too vague. Be precise about what's alleged to have happened, when and where. Ensure they understand the confidential nature of the information and who they can and can't disclose it to. Where there are multiple parties, you will need to check whether the information in the complaint needs to be redacted in any way before sharing it with anyone. Redacting information in a document means to remove or conceal sensitive or confidential information while leaving the rest of the document intact. Only information relevant to each person should be shared with them. So if, for example, a part of the complaint only relates to person B, then you would redact it from the information shared with person A. Also, one of the first things to do is to consider if any controls need to be put in place until the matter can be addressed. If behaviour like bullying or harassment has been alleged, it wouldn't be appropriate for you to just leave the person who has complained working with the person that they're accusing in case bullying or harassment has occurred and could continue. So while you're finding out facts and working through the matter, you need to consider controls such as whether two parties can work in different areas at home or use methods of communication other than talking directly to one another. And that might include an email for work matters only and have all emails copied to the manager. You should consult with the parties about the controls and then monitor their effectiveness and compliance with them. You may also offer support, such as some paid confidential counselling sessions to the parties. The next step in the process is to define the scope of the investigation and the process that will be followed. That usually means drafting a terms of reference, a clear document that outlines what is being investigated, who is involved, the process that will be followed, who will carry out the investigation, and what will happen with any resulting report. This helps set expectations and avoid scope creep. It also provides the parties with an opportunity to consider whether there could be any conflict of interest ahead of the investigation getting underway. During an investigation, counterclaims might be received from other parties, such as those alleged of wrongdoing, and the terms of reference can at that point be reviewed to allow the investigator to include those counterclaims and investigate them as part of the investigation. Parties need to be advised of these changes, as may be relevant to them. You also need to advise the parties of their right to respond, to bring a support person or representative, and that the matter will be treated with confidentiality as far as possible. If someone within your organisation can be impartial and is sufficiently skilled and experienced to undertake the investigation, then you might appoint an internal person to be the investigator. In other circumstances, you may seek an external investigator, and where you do, it's important to ensure they are either a registered investigator or a lawyer, and that they have relevant experience carrying out these types of employment investigations. Whichever option you choose, it's essential that the investigator be independent. The investigator's role is to gather evidence objectively. This includes interviewing witnesses, reviewing documents, and considering both sides of the story impartially. The investigator mustn't consult or chat with anyone outside of the identified parties and witnesses about their potential findings or what their conclusions might be as they work through the investigation. The investigator can't therefore be your HR person, consultant, or lawyer, where that person is also providing you with advice about other actions to take or outcomes once you have received the final report. Having this separation helps ensure it's a fair process. Now, here's where a lot of employers go wrong. They jump to conclusions too early, or they let their own biases influence their judgment. As a registered PI, one of the core skills I bring to investigations is neutrality. You need to be open-minded, professional, and focused on facts. You can't let irrelevant or out-of-scope information come into it. You have to be careful to gather facts with evidence and not just opinions. It can be a difficult role, as often various parties will have strong opinions and can be emotional. The investigator needs to know how to manage meetings and communicate in a way that is effective. Each person involved in the matter must have the opportunity to share their perspective. The investigator should take accurate notes or record interviews with consent, and their questions should be open, not leading. Once they've gathered the evidence, they will analyse it and determine whether the allegations are substantiated or not. Their findings should be based on the balance of probabilities. That means, is it more likely than not that the alleged conduct occurred based on the evidence they have? So, what are today's takeaways? 1. A fair process is essential, even when allegations seem clear. 2. Carry out a preliminary inquiry if needed. Is a formal investigation appropriate, or could informal solutions resolve the matter? 3. Where a formal investigation is implemented and consent from the complainant has been provided to share the details they have, advise the accused of the allegations received. 4. Ensure appropriate controls are put in place and support is offered to the parties involved as may be appropriate. 5. Set clear terms of reference and follow them closely. 6. The investigator must be independent, suitably qualified and experienced. 7. The investigation must be neutral, fact-based and well documented. 8. Don't blur roles. The investigator cannot also be the decision maker about other actions. The information in this podcast is provided as a general overview of key employment topics and does not replace tailored advice. Every situation is different and the appropriate steps can vary depending on the specific circumstances. If you're unsure how to proceed in your workplace, I encourage you to seek advice and support. Feel free to get in touch with me directly. Thanks for joining me on this investigation. If you'd like more insights, or you're dealing with a workplace issue and aren't sure what to do next, reach out. I'm Marie Tovio, and you've been listening to the HRPI. Mā te wā.